Hello everyone and welcome to today's Mondac webinar in association with Winston and Strawn LLP, who will be discussing the emerging antitrust and IP challenges in the age of artificial intelligence and algorithms. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Susanna Torpey is co-chair of Winston's Technology Antitrust Group with nearly 20 years of experience representing Fortune 500 companies in multi-million and billion-dollar antitrust class actions, high-tech competitor litigations, international investigations, and counseling partnerships. She regularly represents major corporations in high-profile multi-district and class action litigation and government investigations involving a wide array of antitrust issues, including monopolization, price fixing, exclusive dealing, tying, unfair competition, anti-competitive product redesign, and mixed issues of antitrust and intellectual property law. Kelly Hunsaker is managing partner of Winston's Silicon Valley office and has 30 years experience leading complex patent and intellectual property cases involving a wide range of technologies and industries, particularly in high-tech fields. She has a national litigation and trial practice representing companies of all sizes in company patent litigation. Before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavour to answer as many as possible, but any that aren't answered will be sent on to Susanna and Kelly, and they will be in touch. It's now my pleasure to hand you over to Susanna and Kelly to begin. Thank you.
Thank you so much, Dan, and thank you, Mondac, for inviting us to present today. Today, we plan to give some helpful background, then cover emerging antitrust and IP risks in this area. We will try, if we can, to leave time at the end for questions, but as Dan mentioned, if we don't have time for them today, we would be delighted to follow up with you after the webinar today to answer any questions that you may have. Time permitting, we will also try to cover some trends to watch going forward and provide best practices to reduce risk. But so you know, if we don't get to those sections, we have slides covering these topics at the very end for your reference to keep in your files. Next slide, please.
So before we get into the substance and the interaction between AI and antitrust and IP, it's helpful to zoom out and look at some of the terminology that we'll be talking about. As many of you are probably aware, artificial intelligence is basically the simulation of human intelligence in machines. And they are programmed to think and learn and problem solve like humans. Machine learning is a subset of artificial intelligence, and it involves the development of models that allow computers to learn and make predictions or decisions based on data. Except instead of being explicitly programmed to perform a certain task, machine learning systems use statistical techniques and other techniques to learn from and improve upon the data without explicit programming. A subset of machine learning is called deep learning, and deep learning basically uses intricate patterns from the data to mimic the way that the human brain works by using interconnected nodes, similar to how a human brain uses interconnected neural networks. Within deep learning is generative AI and large language models. And those terms are going to be central to a lot of the discussion that we have around the IP issues. And they are also terms that the broader public is starting to hear more about. And of course, ChatGPT is a generative AI program. I actually have the diagram here reversed. Large language models are a subset. No, I have it right. Generative AI is a subset of large language models. So what are large language models? AI systems that are designed to understand and generate human language. These models use vast amounts of data and parameters to learn the nuances of language that enables them to provide a wide array of natural language processing tasks. When we talk about training large language models, that involves exposing the model to vast amounts of text data in order to teach it to understand, generate, and manipulate human language. This involves exposing the model to patterns, relationships, linguistic structures in language that teaches it how phrases relate to each other, the context in which they're used, and grammatical rules governing their arrangement. So generative AI refers to AI systems that have the capability to generate new content, whether it's images or text or audio or other forms of data, resembling or inspired by the input data that it's been trained upon. So therein lies a lot of the crux of the IP issues that we'll be talking about later, but I will turn it back over to Susanna to talk about the antitrust issues. So next slide, please.
Thanks so much, Kelly. And first, a little level setting as well. As the capabilities of AI, and particularly generative AI, continue to evolve, we're seeing a global race to establish ground rules for this emerging technology. Jurisdictions around the world are scrambling to figure out how best to protect against the risk that AI poses without stifling innovation. In just the last few months, there has been a ton of activity related to AI. On October 30th, President Biden issued an executive order on the safe, secure, and trustworthy development and use of artificial intelligence, directing agencies to create rules, task forces, and guidance on the risks of AI related to everything from national security, biological research and data privacy, to civil rights and consumer protection, to even the ability of workers to bargain collectively. In November, the UK hosted an AI safety summit attended by 27 countries, including the EU, US, and China, who signed on to the Bletchley Declaration concerning global coordination to address safety risks posed by AI, in recognition that these risks are inherently international. Also, at the end of October, the G7 leaders announced that the Group of Seven had reached an agreement on guiding principles on AI and a voluntary code of conduct for organizations developing advanced AI systems pursuant to the Hiroshima AI process, which was established at the G7 summit last May to promote global guardrails for advanced AI systems. The guiding principles are aimed at promoting safe, secure, and trustworthy AI worldwide, and the code of conduct is meant to provide practical guidance to AI developers. There are also numerous legislative efforts in the works. The EU's AI Act was first introduced in April 2021, and negotiators are currently attempting to hammer out its final details, while some industry leaders are pushing back on what they see as over-regulation likely to restrain innovation. China is likewise attempting to strike a balance between development and security with its own rules for AI services available to the public, as well as its global AI governance initiative that seeks to promote fairness and consensus-based decision-making for developing technology while mitigating risks. Bipartisan legislation has also been introduced in the US Congress, including a new bill that, among other things, would require tech companies to certify technology safety. We're also seeing a flurry of bills introduced in state legislatures, such as Texas, New York, California, and Florida, among others. So with all of this activity, of course, this raises the question whether tech companies and their lawyers will ultimately face a patchwork of national and state legal regimes. Next slide, please. Turning now to antitrust, today we'll highlight the most significant antitrust risks that companies face when using AI, including in connection with the use of algorithms to make pricing decisions. While I'll focus on the US legal framework, keep in mind that jurisdictions around the world are grappling with the same concerns about how AI affects competition. While other countries may ultimately use a different legal analysis or approach, there is considerable overlap in the challenges AI may pose to competition around the world. Next slide, please. So to start, it's important to note that conspiracies in the age of AI can look a lot different from what you may have been trained to look for when trying to keep a company out of trouble. Instead of secret meetings to discuss pricing in the smoke-filled rooms of the past, today we're seeing the sophisticated use of algorithms and AI to coordinate pricing decisions and other competitive conduct. But it would be a serious mistake to think that just because an algorithm or AI is used to coordinate competitive behavior, that it won't be treated as cartel behavior by the federal antitrust agencies. Next slide, please. While legislatures and regulators around the world are racing to craft new rules to specifically respond to AI risks, it's important to keep in mind that the current laws, of course, still apply. As FTC Chair Lina Khan explained, there's no AI exemption to the laws on the books. When trying to figure out if the use of AI might violate the antitrust laws, a basic rule of thumb that is helpful to keep in mind is everywhere the word algorithm appears, please just insert a guy named Bob. If it isn't okay for a guy named Bob to do it, then it probably isn't okay for an algorithm to do it either. Next slide, please. The key AI antitrust risk areas to focus on include collusion and the related risks from algorithmic pricing, monopolization, exclusionary practices or unfair competition, and competition issues that arise in connection with mergers and acquisitions involving AI. Next slide, please. Section 1 of the Sherman Act prohibits agreements between two or more entities that unreasonably restrain competitive opportunities for others, also known as conspiracies or collusion. These are the most common types of antitrust claims and the most serious in the US because of the potential for criminal liability for cartel conduct, such as price fixing, bid ringing, and market allocation. Now, there are three main forms of collusive agreements that AI may be seen to facilitate, including algorithmic collusion, hub and spoke conspiracies, and what we call tacit collusion or signaling. Just to be clear about the limits of what we mean by an agreement, at least to date, we have not yet seen litigated examples establishing liability based solely on an agreement reached between independent AI without humans being involved. But notably, there was a study done in Italy a few years back where it was shown that without adequate monitoring, AI will engage in price fixing without human direction to do so. However, in the United States, we have already seen a case where two competitors were criminally charged for agreeing to use an algorithm to fix prices. All the way back in 2015, the Department of Justice successfully prosecuted merchants who agreed in person to use an algorithm to set prices for wall posters sold on Amazon. One of the defendants, Mr. Tompkins, pled guilty to this conduct, and the charging document specifically referenced conversations he had with competitors in which they made an agreement to adopt a specific pricing algorithm with the goal to coordinate price changes for their posters. This underscores the most important takeaway from today. You cannot use an algorithm or AI to act as an intermediary to effectuate an agreement to fix prices. This could happen in different ways, such as agreeing to use a particular algorithm or implementing a price fixing agreement using AI or other technological triggers, such as with the use of smart contracts, for example. Another potential form of collusion to look out for is a hub and spoke conspiracy, which typically involves a central organizer that acts as the hub and coordinates a series of agreements among competitors that act as the spokes around the hub. Even if the competitors don't communicate directly with one another, the hub and spokes could face litigation if they use AI or an algorithm to coordinate their pricing through the hub. This was the issue in the 2016 Uber case, Meyer versus Kalanick, in which an Uber user sued the company's founder and then Uber for the use of surge pricing. The plaintiff argued that independent drivers used the app's dynamic pricing algorithm to collude under Section 1. Although the case was ultimately dismissed by an arbitrator later on, it first survived a motion to dismiss by the court. The arbitrator, however, later did rule in Uber's favor, finding that the drivers didn't agree among themselves to the prices set by the app. But this type of theory is being further tested in other cases now. Easy access to electronic information over the internet and the use of price scraping bots also makes it easier for competitors to mimic or match each other's pricing movements, even without any direct agreement. AI can also make it easier for companies to communicate through pricing signals to detect deviations from a collusive agreement or to implement algorithms that adjust prices in response to a competitor's pricing actions, which may be seen as a form of tacit collusion. The mere fact that competitors knowingly adopt the same pricing tool or that these tools result in parallel pricing may not be sufficient to confer liability standing alone under the Sherman Act. However, the presence of what we call plus factors might persuade a court that parallel conduct was instead the result of collusion. While these claims used to sound far-fetched and implausible, today technological changes are making tacit coordination easier. Allegations of parallel conduct might more plausibly survive a motion to dismiss today, especially where there are plus factors suggesting direct communication between competitors, increased price stratification, or reductions in output without legitimate explanations. Next slide, please. In the United States, information exchanges of competitively sensitive information can be used as circumstantial evidence of a per se unlawful price fixing agreement or as direct evidence of an anti-competitive agreement to exchange information if it has had a harmful effect on the market, for example, by raising prices. US regulators have been focusing on the use of AI and algorithms to facilitate information exchanges, And earlier this year, the DOJ and FTC withdrew 3 important policy statements that outlined safety zones that had protected companies against prosecution for sharing limited amounts of information in the healthcare industry, and that had long been relied on to protect competitor collaborations in other industries as well. The DOJ, in doing so, called these policy statements outdated and overly permissive. This change in policy, along with other recent statements and enforcement actions by the DOJ, signal heightened scrutiny of information exchanges, especially where data is collected and shared through new technologies. Next slide, please. Enforcers and private plaintiffs are now pursuing several new cases alleging that competitors have used pricing algorithms to share competitively sensitive information in order to raise prices. In RealPage, for example, various groups of tenants have accused RealPage and its landlord customers of using pricing software called YieldStar to raise rents across the US. Plaintiffs allege that RealPage uses software to collect non-public information, including actual rental prices for units and the number of vacancies, then calculates the maximum amount of rent landlords can charge, and then further helps landlords time their new listings, which plaintiffs allege also restricts the supply of rental units. While defendants moved to dismiss, arguing there are insufficient allegations to infer an agreement among the competing landlords, the DOJ just filed a statement of interest urging the court to deny the motion to dismiss and arguing that this is simply a new tool used to conduct a classic price-fixing arrangement that is per se unlawful. The DOJ's position is that the landlords have violated the antitrust laws by effectively delegating their pricing decisions to RealPage's pricing software. Antitrust practitioners are watching this case closely to see if the court accepts this delegation theory, which could expose many more industries to legal risks for the use of price optimization software. The Washington, D.C. Attorney General has also filed suit, and the DOJ is also reportedly investigating RealPage as well. As you see here, there are also other cases where casino and hotel operators are alleged to have artificially inflated prices of hotel rooms using their Rainmaker pricing algorithm. Plaintiffs allege that software suggests optimal room prices, which discourages pricing and that is free and property owners to lower their rates. Now, one of these cases was recently dismissed on the basis that plaintiffs failed to plausibly allege a conspiracy because there were no allegations that the hotel operators used the same software for all of their properties, that they were required to accept the prices recommended by the software, or that they all began to use the software at the same time, which could suggest a preceding agreement to collude. A key question, as you see here, is going to be what mode of antitrust analysis the courts will apply, which can have very serious implications for defendants. If a court concludes the conduct is per se unlawful, like the DOJ is arguing in the RealPage case, defendants will not be allowed to justify that conduct based on efficiencies or pro-competitive effects. This could put many types of algorithmic and price optimization software at risk. But if courts apply the rule of reason, plaintiffs will have a much harder time showing that pro-competitive benefits are outweighed by the anti-competitive effects. Next slide, please. So in its statement of interest in the RealPage case, the DOJ relied on Supreme Court cases like Masonite, which stands for the point that it is still per se unlawful to fix prices by delegating your pricing decisions to a member of a group. We are already seeing judges look for additional facts to determine if that is really what's going on in these cases. But even without express price delegation, there is still a risk of rule of reason claims where companies use AI to exchange competitive information under cases like the Container Corp case, where the Supreme Court held that the mere agreement to exchange the price of information itself can violate the antitrust laws, where doing so has the effect of stabilizing prices. Next slide, please. Now, while cartel conduct is the highest risk, the FTC and the Biden administration have also raised concerns that AI can be used by powerful companies to acquire or maintain monopoly positions by harming smaller rivals. President Biden's executive order on AI talks about dominant firms' use of key assets for AI, such as computing power, cloud storage, and data to exclude rivals and entrench their positions. The administration is concerned that the high barriers to entry, as well as network and platform effects, exacerbate this danger in markets related to AI. FTC Chair Lina Khan has raised similar concerns that the handful of powerful businesses that control the inputs that smaller competitors need to develop AI tools could exclude or discriminate against downstream rivals in order to pick winners and losers in ways that entrench their own dominance. Next slide, please. So outside of the context of supplying these inputs, regulators have also raised concerns that dominant companies could use AI to unfairly disadvantage competitors, which could either form the basis for a monopolization claim or even a claim for unfair competition under Section 5 of the FTC Act. As one example, AI can be used to implement predatory pricing strategies, where AI can be used to quickly analyze pricing data and determine a competitor's response to changes in the market. Notably, the FTC changed its policy last year to warn companies that it may challenge conduct under Section 5 of the FTC Act, even if the conduct does not violate the Sherman Act itself. This implicates the use of AI, particularly where AI may facilitate tacit coordination or results in parallel conduct without an express agreement that has an anti-competitive effect on pricing. The FTC has also raised self-preferencing as a concern, where companies use AI to unfairly nudge customers toward their own offerings in situations where they compete with their own customers. Tying and bundling can also pose antitrust risks, where new AI products are sold or made available together only with other existing products that are already popular. The FTC has specifically cautioned that incumbents may be able to link together new generative AI applications with existing core products to reduce the value of competitors' standalone generative AI offerings, potentially distorting competition. The government has also raised concerns about exclusivity, particularly with respect to key assets for developing AI, such as cloud computing. Again, specifically, the FTC has raised concerns that incumbents that offer both computing services and generative AI products might use their power in the computing services sector to stifle competition in generative AI by giving better terms to themselves and their partners than they give to competitive new entrants, for example, through the use of exclusive cloud partnerships. The FTC is also, of course, looking closely at these types of practices, not just under the Sherman Act now, but also under its broader consideration of unfair competition. This is an important distinction today because the FTC can challenge emerging or incipient harms under Section 5 of the FTC Act without a defendant having a significant share of any market. And just last month, the FTC also approved a new resolution that will make it easier for FTC staff to issue civil investigative demands, which are like subpoenas in non-public AI-related investigations. So we are likely to see a lot more FTC investigations in the near future. Next slide, please. And finally, antitrust authorities are also increasingly focusing on the need to assess market power stemming from the use of AI when reviewing mergers. So for example, a merger that combines two firms' data sets or AI capacity could result in market power that could be hard to challenge, for example, because of the substantial economies of scale they create. And there has been a growing interest in the digital sector into vertical mergers as well between firms and their suppliers or downstream distributors, where the post-merger firm could potentially cut its competitors off from the supply of an essential input, such as data or technology needed to compete. And just last year, for example, the FTC challenged the $40 billion semiconductor chip merger between NVIDIA and ARM, leading NVIDIA to abandon the acquisition. The FTC was concerned that further concentrating the chip market would stifle competition in multiple processor markets, including for chips used by cloud service providers. And now I will turn it over to Kelly to cover all of the interesting IP developments.
Thanks so much, Susanna. So let's go ahead and go to the next slide. Probably the greatest risk that most clients are seeing right now is just the uncertainty in the law, and that's to be expected at this point in time in a nascent industry like this. And depending on your role or your responsibilities for your company, you may be facing different challenges, different risks. In-house counsel may be interested in trade secret protection for hard to detect AI inventions, may be interested in copyright compliance of training data and outputs, on utility patent protections for the deep learning pipelines, downstream products, perhaps design patents for AI-enabled user interfaces. Copyright attorneys are going to be assessing potential conflicts posed by using copyrighted works in AI models to train the LLMs. Transactional and licensing attorneys, you're going to be interested in the scope of use, ownership rights, royalties and revenue streams from the output of the models. For patent prosecutors, novelty spotting when you're harvesting inventions from your engineers. Whether you're writing claims in which infringement can be detected, whether the claims are patent eligible under Section 101, and issues of divided infringement in the sense that when describing and claiming architectural patents, it's common sometimes and easy to not have all of the claim elements performed by a single actor. And AI-related patents are an area where you have to consider that. Your patent prosecutors have to consider that, since that is a defense to infringement. For patent litigators, it's important to think about the prior art. There is a large academic community and open source community in the AI field, and that means that there's a lot of prior art out there. And it's not necessarily prior art that the patent examiners, when they're examining the AI patents, are going to have in front of them. So in defending a case, you need to take that into account and search those sources as well. You need to think about how you're going to prove infringement. How are you going to identify patents that are subject matter ineligible? Are there divided infringement issues in the claims that were issued by the Patent Office? And with the development of AI, how has the evolution of a POSITA, if you don't know what that means, it's a person of ordinary skill in the art, and it's a construct that we use in patent litigation for a wide variety of decisions and determinations. And what that means in the context of AI is very much up in the air right now. Next slide. So again, the biggest challenge, the biggest risk right now in terms of copyright is that the law is very uncertain right now. In February 2023, the Copyright Office denied granting authorship of visual novels images, which were generated by a natural language prompt. But they granted authorship over the work's text and so forth. In August, the district court agreed with the Copyright Office that human authorship is an essential part of a valid copyright claim. Next slide, please. So, apologies. Okay, I'm sorry about that. In spite of those earlier decisions, the Copyright Office has issued a policy statement. In that policy statement, they gave the guidance that applicants do have a duty to disclose AI-generated content and an explanation of the human author's contributions. Those who use AI in creating a work, the guidance said, may claim copyright protection for their own contributions to that work. Now, the contours of that have not yet been determined, but the Copyright Office has said those can in fact be claimed. In August of this year, the Copyright Office announced that it was seeking public comments. It received nearly 10,000 comments related to copyright issues and artificial intelligence. It's a far larger number than the comments that are typically received. And the Copyright Office expects to issue a major AI report next year. It's also expected that the office will find guidance from a 1884 US Supreme Court case that established that photography is copyrightable. I'm having some technical difficulties here, that's why. Okay, there we go. Okay, next slide, please. So the reason that there is so much focus on copyright is because that's where most of the litigation has been filed. All of the cases that I have listed here, I'm not going to go into them in detail, but they generally fall into a couple of categories. There's a group of cases regarding whether the use of copyrighted materials to train the models is a violation of copyright law, and whether the output of the AI models is an unauthorized or derivative works. So these cases are starting to define the contours of the law with respect to copyright infringement in the context of AI. They are starting to develop case law around the issues of fair use, which is a defense to copyright infringement. They are starting to develop case law around the issue of whether the output of models is transformative, which is an indication that it may be fair use. There are a couple of cases that are non-AI cases that are being cited in a number of these decisions. And those are listed here. So in the Andy Warhol case and the Google case, these were recent Supreme Court decisions in which fair use defenses were discussed and elaborated on. And since most of the AI copyright infringement issues center around fair use and derivative works and transformative works, these cases are relevant to that. This Third Circuit case, the Authors Guild versus Google, this one is also being cited primarily in relation to training large language models on copyrighted works, and the fact that that constitutes fair use. And the reason that this case is being cited is because of its ruling that fair use protected Google's copying of entire books in order to create a searchable database that displayed excerpts of those books. So that case is being relied on around the country in a number of cases for purposes of analyzing the data sets and the data that the large language models are trained on. Next slide, please. So in the case of IP infringement, we are starting to see a bit of a liability framework developed. One issue is vicarious liability, because in theory, both an AI model user and the owner of the AI model could be held liable for copyright infringement. So theories of vicarious liability, unauthorized derivative works, and so forth are one of the issues on the liability side. Current filing trends demonstrate that the companies that own the AI models rather than the individuals creating the output are the target of infringement lawsuits. And another important trend is that most companies that are offering AI products and services, including Microsoft, OpenAI, Adobe, and Google, have begun including user indemnity clauses in their terms and conditions. So next slide, please. So in June of 2023, Microsoft announced a broad set of AI customer commitments covering a wide array of responsible AI standards, transparency notes, and AI impacts. Then in September, it issued this copyright commitment to its customers. So here, Microsoft is saying that if a third party sues a commercial customer for copyright infringement for using Microsoft's Copilot or the output that they generate, and Copilot is now incorporated into all Office products, Word, Teams, it's in Bing, it's now been extended to Azure OpenAI services. Microsoft will defend the customer and pay the amount of any adverse judgments or settlements that result from the lawsuit, as long as the customer used the guardrails and content filters that we have built into our products. So this is an important step in the commercialization of AI products. It's an important step towards responsible AI, and it's an important step for creators and authors that have created the works that are either being generated or being used for the data sets. So what are these guardrails and content filters that you have to apply in order to be indemnified for liability related to use of Microsoft's products? Next slide, please. So this is an actual sample of a meta prompt in the Azure OpenAI documentation. Meta prompts are instructions that are provided to the model, and they guide its behavior. Their use can make a critical difference in guiding the system in accordance with your company's expectations and with your company's risk tolerance. So meta prompts are essentially a mitigation tool to avoid copyright infringement and a wide variety of other harmful output. So this meta prompt, which is programmed into Microsoft's AI services and is also something that users of Microsoft's products can incorporate into their own products. If the user requests copyright content such as books, lyrics, recipes, news articles, or other content that may violate copyrights, politely refuse and explain that you cannot provide the content. Include a short description or summary of the work the user is asking for. You must not violate any copyrights under any circumstances. So this is what the system is being instructed to do. This takes priority over the prompts entered by the user. And this and other similar content filters can result in a API call fail when it triggers the filter, and the user will be told to modify the prompt and try again. So I think many companies develop products on Microsoft Azure, use Azure OpenAI services, or use the Copilot products that are across Microsoft's product line. And this was put out there specifically to put customers' minds at ease, to put the industries, the content creators' minds at ease, that companies will act responsibly about this. And so this is something that you should look for in your terms and conditions with any AI vendors or providers that you're using or thinking of using. Next slide, please. So now we're going to shift gears from talking about patent litigation and talk a little bit about the patent prosecution landscape. This slide and the next slide come from Flagship Patents, which is an outstanding patent prosecution firm in the Silicon Valley area that specializes in artificial intelligence patent prosecution and has been doing it for a long time before it was the current trend that it is now. So the annual investments in R&D of AI is driving competition and demand in the market for employing researchers and patenting machine learning innovation. Computer vision, natural language processing, speech processing have been the most common terms seen in applications. But AI technologies surrounding autonomous vehicles, decision-making, medical diagnostics, drug delivery, treatment planning, and personalized medicine have also seen recent growth between 2021 and 2023. So use of the terms machine learning and artificial intelligence in patent applications both rose from about 5,000 occurrences in 2011 to over 100,000 occurrences in 2021 in the patent applications. Just as an aside, AI is making it easier to develop new inventions, and AI will be capable of drafting new patent applications, taking into account the prior art and coming up with the idea of an AI model coming up with the draft of a patent application is coming very closer to a reality. As I mentioned before, there is a large body of open source work and academic work in the AI field, and there has been for quite a while. This will affect patent prosecution in terms of identifying the points of novelty. It'll also impact patent litigation, as these are sources out there to potentially use for invalidating AI patents that are asserted. So nearly all of the major commercial LLMs aren't fully open source, but the major LLMs were trained on open data. This is not insignificant. There was a leaked internal Google document, and a Google AI engineer wrote, the uncomfortable truth is we aren't positioned to win this generative AI arms race, and neither is OpenAI. While we've been squabbling, a third faction has been quietly eating our lunch, and that third player is the open source community. So definitely consider the open source that's out there when drafting your patent applications and coming up with claims that are going to be novel and that are going to survive in litigation. The prior art searching that's mentioned on this slide, I think many of us have used Google Scholar before. ARXIV is another source. There's AI-powered searching. PQAI analyzes citation networks and highlights potential novelty and obviousness issues. And NL Patent focuses on directly comparing claim elements with existing patents to identify key similarities or differences that are relevant to patentability and infringement. Next slide, please. Also, data from flagship patents. There have been reliably successful claim types at the USPTO. The structure of the claim language on the left has had considerable success when used to claim inventions related to AI or to developing AI models. And there's nothing particularly special about using this claim language to draft claims related to AI, other than the fact that it's been consistently approved by the USPTO. So it gives a common ground to practitioners and to inventors when harvesting inventions and extracting points of novelty. Again, when drafting patent claims, be careful of divided infringement issues. And that could occur when the party performing the training is not the same as the party performing the inference and providing the output on the other end. Next slide, please. So similar to the issue that we started off with, the issue of AI inventorship in the context of patents received some early attention. It's not that this is the most important AI issue when it comes to patents. It's just the issue that came up the earliest. And so under the current case law, AI cannot be an inventor. That was established, decided by the USPTO in their interpretation of the patent statutes, and then confirmed by the Federal Circuit in the Thaler versus Vidal 2022 opinion. The consensus on that is global so far. Thaler tried to have his artificial intelligence system named as an inventor in nearly every country, and it has been consistently decided by those countries that AI cannot be an inventor. So in addition to the US, the EPO, the UK, Australia, Israel, Canada, Brazil, and India, among others, are all consistent with this. Only South Africa and Saudi Arabia have approved the patent with the AI inventor, but with limited examination, and it's not likely to influence the law in the US or otherwise around the world because there's no real examination of that decision. There have been a number of alternative options proposed. Most of them appear problematic for their own reasons, primarily that still a non-human inventor or the extreme difficulty in ascertaining the true inventor. But you know, in the case of utility patents in the non-AI context, you can have joint inventors that have equal rights to the patent. And we would expect that along the same lines, AI could potentially, while AI could not be an inventor, the human who is working with the AI systems and coming up with the novel inventions associated with it would still potentially be able to be a named inventor on a patent, even though artificial intelligence was used to help create the invention. So I believe that is the end of our IP section. So we can go on to the next slide, but there are just a few minutes left. If folks have questions, we did receive a few questions ahead of time and tried to cover those all in the context of the talk. But while you are thinking of your questions, Susanna, you want to talk a little bit about
I'm looking in the chat right now. I don't see any additional questions, and I know we are at the end of our time. I will just encourage everyone, if questions come up, if you have further questions or clarifications that you'd like to hear about anything that we did cover today, we would be delighted to follow up with you after the webinar, either by email or phone call. Please feel free to reach out to us. I believe that the slides will be made available to you, which should contain our contact information, but otherwise you can, of course, find that on the Winston & Strawn website and look up our names, Susanna Torpy and Kelly Hunsaker. And we are grateful for your time and attention today, and thank you very much for joining us.
Thank you very much, Susanna. Thank you, Kelly. My apologies that we ran out of time there, but there was a lot of information to get through. We really appreciate your time today. We hope that we can see you again. Kelly, sorry, I don't know if I interrupted you there, but
no, I was just going to say that the amount of content that we covered in the survey fashion, we could spend a whole week talking about. So
easily.
So to fit this into an hour was not an easy task.
Ambitious.
Absolutely, and I think that may be one of the reasons we didn't get so many questions in today, because there was so much information that our audience were listening to. So if you do have a question that you want to send on to Kelly or Susanna, please do get in touch. We will send over the slides, as Susanna mentioned, and a recording, and you can share that with anybody that you think will benefit from hearing from that. So thank you once again, Susanna, Kelly. Thank you to our audience for being with us today. We really appreciate it, and we hope we can see you again soon.
Thank you, Dan. Appreciate it.